tracking developments in the trial of 3 Tacoma police officers in the death of Manuel Ellis. Thanks for joining us. I'm Christine Pay. Ellis died while being restrained by police in March of 2020. Officers Matthew Collins, Christopher Burbank, and Timothy Rankin are all facing charges in his death. King 5 is live streaming the entire trial from opening to closing statements. We take you now to the courtroom live.
Okay. Great. So we'll expect to talk about that tomorrow. Are we otherwise ready for the jury?
Mr. Conrad release the custodians?
He can. It looks like he's got time to do that while we get the jury. So let's get the jury. Mr. Nielsen, if you're here much longer, we may have to charge you rent. Clear the calendar for tomorrow. Okay.
How much is rent?
It's pretty nominal, actually.
Okay.
Sadly, that's what the fair market value is. Nominal. Mr. Conrad, you're beginning to remind me of Columbo. Just when you think the conversation's over, he turns around and goes, "Oh, one more thing." He may have no idea what that reference is. That's true.
I'll look it up.
No, remember, it's Columbo, not Columbus, as you're looking things up. All right, welcome back, everybody. Please be seated. Okay, redirect examination, Mr. Fricke.
Yes, sir. I just have a few questions. Good afternoon, one more time.
Hello.
First of all, Ms. Nicolai, I want to ask you about basically doing police work as far as consulting with groups. Recall that question?
Yeah, there were a series of questions. Yes.
Yeah. And have you ever advised in your capacity as a consultant, whoever you were working for, that they ought to consider settling cases?
Yes, I have.
Police agencies?
Correct.
Yeah, or police officers?
The agencies typically, yes.
And that's based on your review of the records as they gave them at that time?
Yes, that's correct.
Okay. Now, when you're doing police work and in your training, what's the most important consideration for the officers out on the street?
It's always safety.
And why is that?
Well, I mean, that's one of the fundamental, obvious duties of the profession is to try to ensure some measure of safety.
And in the context of safety consideration, what do you train officers to do when they're presented with a situation involving a subject?
Yeah, well, earlier we talked about, I think much earlier we talked about the the priorities of work when you show up on scene, right? And that's render the scene safe, render any medical aid that's needed, and then investigate crime in that order. And sometimes they flux. You might have a scene that's stable, and then it becomes dynamic again, and you might be at the investigating crime stage, and then something might happen where you need to resecure the scene. But that process of rendering the scene safe requires timely decision making, always. You have to make sure that you're making decisions at the appropriate times so that you can help impact safety, right?
And why is that? And so, as far as making the appropriate decision in a timely fashion, if you don't, what's the risk?
Well, and I think we've talked about this, excuse me, earlier as well, is that when the police show up, they're often the least informed party to the event. Like I said, we show up and they don't know the people involved typically. They don't know their motives. They don't know their capabilities. They don't know their intent. And so it's an inherently predictive endeavor. Like you're required to make predictions about things that could possibly happen or that may likely happen and then act accordingly. And the irony is that if you just wait long enough, that every prediction will become true, right? So if the person reaches into their pocket and you think they might have a gun, well, if you wait long enough, you'll certainly find out. But the key is to be able to make a prediction far enough in advance that you still have time to impact the outcome. So if the gun comes out and it's pointed at you, that's far too late. You don't have a lot of opportunity to impact the outcome at that point. So you have to act in a timely way so that the predictions that you make can still impact the future in a meaningful way for what you're trying to accomplish.
Which is, and certainly in that context, keeping yourself safe as well as the public safe.
Certainly, yes.
Now, when you were doing the demonstration here earlier this morning with the handcuffs, obviously it's a controlled situation.
Correct,
And
yes.
Are you suggesting that easy to put handcuffs on an individual out in the street who's resisting?
No, not under real world circumstances, if they're resisting.
It's just to show the technique used, is that right?
Yeah, and what I did, that happens when people comply. So for example, if you, I think talked about earlier about arresting somebody out of a stolen car late at night, you might use a technique like that and they'll comply. And it would look just like we did it. But if there's resistance involved, those principles will still apply. You'll still try to control sectors of the body. You'll still use your body weight to control their resistance, like those kinds of things. And the point was that's a trained principle, is that when people are prone on the ground, you have to control them. And one of the ways you control them, one of the ways, is to leverage your body weight against the person according to the level of resistance.
And you showed one method of putting handcuffs on a subject. Are there other ways to do it as well that are identical to what you did here this morning?
I mean, I could have done it from his left side.
Okay. Sorry. And then I just want to be clear, when Ms. Bremner was asking questions about once Mr. Ellis was in handcuffs, you had indicated it wouldn't be appropriate to hit him at that point.
Correct.
Right. You weren't suggesting that it was inappropriate for officers Burbank and or Collins to hit him before he was in handcuffs. Is that correct?
Correct. That's a much different set of circumstances.
Okay. And when you apply the Graham factors, and the three factors are is the seriousness of the offense,
Correct.
the threat to the officer in public,
Correct.
and the third one is?
The third one is the efforts to resist apprehension or avoid arrest.
And when you look at those, is each one 33% of the equation, or do they fluctuate? As far as the importance goes.
Yeah, it could be. They could be all even depending on the circumstances, but they're often different. So, for example, you could have a low-level crime and a low risk and vigorous efforts to avoid apprehension, right? And so you would have to. That would obviously be the most salient factor of the three. Now, that doesn't give you license to just do whatever you want. You still have to react according to what the resistance is that you're getting. Or conversely, you could have a very serious crime, like you're arresting a murderer, for example, and he comes out with his hands up, right? Which is that wouldn't justify any force, even though it's the highest level of crime that you could have. So you wouldn't use a bunch of force under those circumstances. The resistance and the danger would be very low, with a very high level of crime. So you see how there's a relationship, there's interplay between those three
And they can
factors.
shift depending on the situation.
Not only on the situation, but within the situation itself. Yes.
And then finally, as far as Ms. Bremner had asked you, was in reference to Mr. Rankin, Officer Rankin, was based on an objective standard under the Graham factors, was it appropriate? And of course, your response is yes. The Graham factors, correct, take into consideration that the subjectiveness of what's going on with a particular officer at the moment of the event.
Correct. So there's a subjective component, right, based on the officer's training, experience, knowledge at the time, right, and then you evaluate that objectively according to what an officer under the same or similar circumstances would do. Correct. So it's not wholly objective. It takes into account the officer and what they know and their training and what they bring to the event.
And the objectiveness is, but still, looking at what they did at the time, it's not like second guessing them. And there may be, I think you indicated sometime yesterday, for instance, that there may be 3 or 4 different alternatives an officer can use, but so long as he uses one that's reasonable, that's fine, correct?
And that's often the case, yes.
Okay. That's all I have, sir. Thank you.
Mr. Nielsen, you testified this morning about the risk of positional asphyxia. And you're aware that officers have been trained for over 25 years about the risk of positional asphyxia
Correct.
and identifying those risks
Correct.
to include people that are obese are at a higher risk,
Correct.
to include people that have pre-existing conditions like a heart condition are at risk.
Yeah, but there's typically no way of knowing that. But yeah, if you had an opportunity to discuss it with someone that said I have a bad heart, you would take that into account.
And officers know that they don't know pre-existing conditions for civilians that they are encountering, but there's a possibility of those pre-existing conditions.
Yeah, many things are not only unknown, but unknowable, yes.
And they've been trained to specifically take steps to reduce the risk of positional asphyxia.
Yes, they're aware of the risks, like with any use of force, and they're trained to take steps to mitigate those risks. That's correct.
Including getting someone up out of the prone position.
That's one, yeah, when appropriate.
Including getting somebody up into the recovery position.
Correct, when appropriate.
Including not having any weight on someone when they're in the prone position.
That's not true.
They're not trained to not put weight on somebody when they're in the prone position to reduce the risk of positional asphyxia.
Is your question, are officers trained to never put weight on people in the prone position?
Not my question.
Okay.
Asking her the question, I think I'll overrule the objection. So
The question
go ahead and ask your question, Mr. Nielsen, and what you were trying to get clarification from Ms.
Your Honor, I
Nicolavo.
can clarify for.
Okay.
The question is, officers are trained to reduce the risk of positional asphyxia to not put weight on the back of someone who is in a prone position.
No, that's not true. That's not true. If someone tells you that, that's untrue. They're trained to put no unnecessary weight on people. And every policy that you read will say unnecessary weight. There are no categoricals. That is not true.
You would agree that weight on the back of an individual who is in the prone position can increase the risk of positional asphyxia.
I would agree to that. And here's the issue. May I answer the question, please?
You did answer the question.
I'm not finished answering.
I'll allow him to continue. Go ahead, Mr. Nelson.
The problem is when you conflate likelihood, the increase in likelihood, with likelihood at large. And so if something is, say, 0.5% likely, and you double it to 1%, now mathematically you've just doubled the likelihood that's going to happen, but it's 99% unlikely that it will happen. And so don't conflate increased likelihood with probability. And that's I think, the problem that you and I are discussing, is that you say, is it more likely? Yes, it's more likely. And it may go from a remote possibility to even a less remote possibility, but not likely.
Mr. Nielsen, have you done studies and research in positional asphyxia?
I have not.
And have you done publications in positional asphyxia?
I have not.
And have you stood there and watched someone die from positional asphyxia as it happened in this case?
It is, I don't think it's completely unreasonable to ask about his experience. Has he had any personal experience with positional asphyxia and trying to accomplish an arrest? I think that's the gist of the question. Maybe put a little less dramatically, but nonetheless. Do you have such experience, sir? And if so, could you tell us what it is?
In the 13 years that I've been doing this, in the thousands of arrests that I've made, under a variety of circumstances, I've never once seen it happen.
And in those 13 years that you've been doing that, that's in the variety of arrests that you've made and the number of circumstances, do you ever put both knees down on an individual's back and lower neck, base of their neck, when they're in a handcuffed prone position and they are hobbled and they have said, I can't breathe?
I object to the characterization since that's not evidence. Characterize the evidence.
We'll overrule the objection.
I can't recall that I have.
And you're certainly aware of cases where people have died in custody due to positional asphyxia.
I'm aware that it happens.
I believe on Monday you brought up the Garner case in which he died.
Your Honor, I object, this goes beyond the redirect.
I join in an objection, or it goes beyond my
Sustained. Sustained.
You testified on cross, I don't recall, it may have been with multiple defense attorneys, about the magazines,
For the firearm?
the Glock magazines.
Correct, yes.
And you wrote a report in this matter, Exhibit 2133, permission to approach, Your Honor.
Sure.
And part of this report includes the materials, a list of the materials you reviewed, correct?
Correct.
All right. You agree it's important to include facts that are relevant and crucial to your analysis in the report, correct?
Sure.
Can you show me where you include the indication in there from Lieutenant Rankin that he was in fear because he saw magazines? Or a magazine for a Glock when he approached the scene?
Your Honor, it's a lengthy report. Perhaps
Well, I don't know that lengthiness is sufficient to object. I don't know, how lengthy is this? I've heard this called lengthy before.
Your Honor, I'll save the court some time. It's not included.
Well, that's your opinion. I may be in there or not. I'll ask the jury to disregard. The only question I asked was how long is this report? How many pages does it consist of?
Are you asking me, sir?
Yes.
It's 62 pages.
62 pages.
Would the strike get to
Yeah, the jury should disregard the comment of Ms. Nicolavo.
I just asked, where in that report does it state magazine, that Ms. Rankin found a magazine at the scene?
I don't know if I put the magazine in here. And I don't know if I would have, I don't know if I put it in the context of Rankin's observations. I mean, if you want me to, I could read through this whole thing. But I don't, if I did put it in here, I don't think it refers to Officer Rankin.
But you testified yesterday, actually you testified on Monday, that you didn't include any analysis of Rankin's conduct. You just included the conclusion that he was justified and his conduct was reasonable, right?
Objection is asked and answered.
This is for foundation.
I don't know if he had he did indicate he didn't analyze Officer Rankin's work. I don't know that he made any conclusions about it because I haven't seen this report. So I don't know, maybe that's in there, it isn't. So, so what's your question? Did in his report, does he reach a conclusion about Officer Rankin? Is that the question?
Your Honor, the question is, in the report, he contains a conclusion without an analysis for defendant Rankin's.
No, I don't know. Ask him if first there's a conclusion.
I asked him about the conclusion
No,
last time, so
I don't know about
the
that.
conclusion is.
Was there
Is there a
is
conclusion?
there a conclusion?
There is a conclusion.
Right. And you included, as you said.
Yeah, did you want to ask him, how do you reach a conclusion without an analysis? Is that your question?
No, Your Honor, that's not.
All right.
And you answered on cross by Ms. Bremner that you included a couple pages of fact section regarding defendant Rankin, correct?
Correct. I mean, there was facts, yes, and his facts were among them, yes.
And you pulled those from his statement, correct?
Correct.
And in your report, you did not include the portion of his statement regarding the magazine, did you?
Asked and answered.
Just go ahead. Go ahead.
I don't believe I did.
And you did include an analysis of how the magazine could have played a part in his conduct, did you?
Not in the report, no.
And I appreciate you taking a look at that. I'm going to hand, Your Honor, can I approach freely?
Sure.
I'll take that one back from you and hand you State's Exhibit 65A. 65A. The 65A has previously been identified as a transcript from defendant Rankin's interview with Detective Brockway. I believe you've had an opportunity to review it maybe in a different form, on a different print up without pleading paper.
Yeah, correct. It didn't look like this, but I'm pretty confident this is probably the same thing that I saw, just formatted differently.
And I want to take you to page 11. And
Sorry.
you got page 11?
Yep, I am.
And defendant Rankin, in his statement, where he is addressing the magazine, he states at line 16, as we were transitioning, I remember Officer Ford asked, whose magazine, whose Flock magazine was on his lower back? And no one answered. And I just remembered, I remember Officer Ford grabbing it and just tossing it, because I remember seeing the magazine slide away and from the subject. And as I transitioned up to the torso, we had me and Officer Burbank had made a plan that I was going to take the right side, right half of his torso, off the subject's torso, and Officer Burbank was going to take the left side of the subject's torso. You recall reading that?
Not specifically. It was of the subject's torso, not off.
Thank you for the correction.
But no, I don't. I mean, not specifically, but this is generally consistent with my understanding of the event.
And that's the only place in his interview where he addresses the magazine that was actually found on Mr. Ellis's back.
I don't know. I'd have to read it again. Yeah, which I can do if you like, but I don't know his answer.
And there's nowhere in that report, in his interview, where he expresses any fear of that.
Are you telling me or asking me?
Correct? I'm asking you, there's nowhere in this interview where he expresses fear due to finding a magazine.
I don't know. I'd have to read it again. It's possible, but even if that were true, if we assume that were true for your question, it still wouldn't be unreasonable to take that into consideration under those circumstances.
But you would have included that in your report if it was something that he noted was of concern to him, and that he was afraid or had fear because of it, that Mr. Ellis was armed.
I mean, I suppose I could have, but we discussed it today.
And in fact, wouldn't it be proper police procedures if an officer found a magazine and thought it actually belonged potentially to the subject to call out gun or to call out he might be armed?
I mean,
Sorry, go ahead.
yeah, if he thought there were a gun, yeah, but yes, if he thought there were a gun.
And TPD is the officers, the firearm that they use is a Glock, correct?
Correct.
Department issued Glocks.
Correct. But they exist in the world elsewhere too, so they're pretty common. But
no
yes,
one was yelling, he's got a gun.
that's correct.
Well, this is kind of argumentative.
I can read
Because I understand the statement, it was Officer Ford who saw the magazine, not Officer Rankin. Officer Ford didn't see a gun, so I would not imagine he would call out gun unless he saw one. So, I'm not sure what this gets at. And,
rephrase.
try.
It surprised you that Officer Ford, when he testified, doesn't even remember finding
Your Honor, objected to.
Glock magazine?
Your Honor, excuse me, objecting to the question and asking comment other witness testimony.
Well, if the issue has to do with what Officer Rankine understood at the time, I'm not understanding his statement to say that Officer Ford called out, it's a Glock magazine, for instance, just a magazine.
Your Honor, his statement says, whose Glock magazine was on his lower back? And no one answered.
Okay, take it back then. But still, what's the significance of this?
Well, we've heard testimony for almost a day and a half about how significant it was that there was a magazine there, and that Defendant Rankin must have been concerned about the safety of everybody because he didn't know whose magazine it was.
I mean, I don't want to inject myself here, but do you find it odd that if a gun magazine was found at a scene, that someone might suspect a gun may be nearby without knowing for sure?
And none of the defendants in this case had that concern or voiced that concern.
Your Honor,
That's not clear. I mean, just because they didn't say I was afraid of this and afraid of this and afraid of this, that it wasn't a reasonable implication at the time in the circumstances. So I don't find this line of questioning particularly productive. And it has become
We'll move on to a
argumentative.
different area, Your Honor.
I think so.
testified on Monday about, and somewhat today, about the caretaking responsibility of officers.
Correct.
And you testified about how important it is when there's a medical crisis to alert that to the fire department and medics.
Yeah, that should happen.
And you testified when defense counsel, Mr. Osser, told you that Defendant Collins went up to the fire department when they arrived and advised them there's potential inside delirium. Recall that?
I do recall that.
And you didn't include that in your report anywhere, did you?
I don't recall that I did.
You also testified about the use of the hobbles,
Correct.
and you never included in your report anywhere that it was a fork. You never included that the hobble was attached to Mr. Ellis's handcuffs, did you?
I don't recall if the only testimony that I gave on the hobbles, I think, was between you and I. I don't know if anyone on the defense asked about that. So I'd like to clarify that. But can you ask the next question again?
In your report, you never included that the hobbles were attached to Mr. Ellis's handcuffs, did you?
I'd have to look at the report again.
I can provide it to you. If you had a section in there on hobbles, 2133. The use of hobbles, section 5 on page 38.
No, I didn't specifically say they were attached to the handcuffs. That's correct.
And I believe you testified with defense counsel Osser that hobbles, when in a 4-point restraint attached to the handcuffs and cinched up behind the back, it can mainly scuff up the knees for injuries that could cause, right?
I don't know if I said that. I mean, that's possible.
And when there's training on positional asphyxia, one of the reasons why officers are trained to not attach the hobbles to the cuffs is because it increases the risk of positional asphyxia. That's it.
Overall, you may answer.
It could increase the risk, yes.
Officers are also trained that when someone is struggling to breathe, that could also look like they're resisting, either thrashing about to try and get in a position to increase their ability to breathe.
I'm going to object. I think this goes beyond this. So certainly redirecting. I think
All right, I'll overrule those objections. You may answer.
You ask it again, sorry.
Officers are trained that when someone is struggling to breathe, they will often thrash about and try and reposition themselves when in the prone position in order to open up the airways and gain breath.
I also object on foundation.
She's asking if that's trained. If officers are trained with this.
All right.
Overruled, you may answer.
They're trained that that's a possibility.
You testified a few minutes ago that you can't, that you're in a position as an officer that you have to predict, right? You have to predict a lot what's going to happen next, right?
Well, what could happen, yes.
Yeah. Because you don't know the status of the person that you're trying to place under arrest, right?
When you say status,
You don't know the condition of that person, do you?
yeah, like I said, some things are unknown and unknowable. You don't know their motives. You don't know their intent. You don't know their capabilities. You don't know, yeah, many things.
And when you're thinking about about the restraint and the risk of that restraint, you have to think about the harm that could be caused to that person, right?
I just object as to
Well, this is the same ground that we've already talked about in terms of escalating responses and why you do it. I don't think that's beyond the pale of what we've heard of already. I don't think it's beyond the pale of all the objection. You may continue.
Sorry, can you ask it again?
You have to consider the risk. When you analyze the degree of force to apply, you have to consider the risk of harm to the subject, right?
Yeah, not only the risk, but the likelihood of risk as well, yes.
And you have to consider if someone states they can't breathe.
You should take that under consideration, yes.
And you should take it under consideration and that it could be a sign of distress.
It could be.
And you should take into consideration if they're non-responsive, unresponsive.
Like they don't speak back to you? I mean, possibly. That's kind of a vague question, but possibly.
Let me clarify it. If someone is handcuffed, 4-point restraint, says I can't breathe, and goes quiet, completely quiet, and doing a 1,000-yard stare. Consider that for a medical distress potential.
object as it being beyond the scope of the directed problem.
Check the characterization of Ryan joining Mr. Bricky's.
Overruled. Overruled, you may answer.
Yeah, you should attend to that. You should summon aid. You should definitely focus on that as a factor of the contact.
You testified a little bit today about the Graham factors,
Correct.
and when you testified about the Graham factors on Monday,
Your Honor, I'm gonna, to the extent she's referring to Monday, I believe that goes beyond the scope of redirected problem.
We haven't heard the whole question.
Your Honor, I would just note that Monday, Mr. Rosser completed his cross.
Just ask your question and we'll see where it's a problem or not.
You're asked about the factors for the Graham factors, right?
Correct.
And went through those Graham factors. And today you told Mr. Fricky that one of those Graham factors is a threat, right?
Yeah, the risk of harm to the officer and the public. Yes.
It includes assessing the threat.
Yeah, I mean we might be saying the same thing, but yes.
Well, when I asked you if it included assessing an immediate threat, you said no, it's risk, not immediate threat.
Okay.
But it is immediate threat is what they are to consider. They're not the same.
Okay.
Would you agree they're not the same?
Hold on a second.
Your Honor, the court wants clarification.
I remember this conversation a little bit, but the context of it is different from this. It had to do, if memory serves, we've already seen my memory can be flawed, but if memory serves, it had to do with this business about taking a 1/30th of a second frame by frame kind of analysis and what's the immediate threat from that, and putting that in the context of what's the entire risk or whatever. That's what I remember.
That's not the area where it was inquired about, and it's on
Well, if we're talking about just immediate threat, then this just now sounds like a semantical argument. So let's be more specific about what you mean.
Certainly. You're asked, when you consider the immediate threat, you also consider things like the number of officers available. Your response was, yeah, but to be clear, it's not immediate threat. It's danger to the officers and others. So I wouldn't phrase it immediate threat.
What's the question?
I wanted clarification. It's immediate threat, is it not? When you're looking at the gram factors and the language, it's immediate threat.
Are you asking me or telling me?
I'm asking you.
Is
that correct?
is the language immediate threat? So is the question severity of the crime, immediate threat, and efforts to flee? An immediate threat is the second one, as I was asking?
Correct.
I mean, I suppose you could characterize it that way. It's just another version of risk or potential for harm. If you want to say immediate threat, then go ahead.
Okay. And you have your report up there with you?
I do.
And if you turn to page 30 of your report,
I'm there.
and the bottom paragraph,
Okay.
and in your report, you were good with using poses an immediate threat to the community or the officers, right?
I did. I wrote that. Yes.
And on page 31, when you talked about officers are trained to tailor force options according to such conditions, as whether the suspect's actions pose an immediate threat of harm to the public or responding officers.
Yeah. Correct.
So immediate threat is the standard in which you consider and analyze the reasonableness of the force.
Sure.
You are asked several questions by multiple parties about the prior case that you were retained on by the Attorney General's office, in which I was one of the attorneys of record.
This is
Recall that?
beyond the scope of your act.
I'll allow her to ask about this. Go ahead.
I object that mischaracterized the separation more than one case ground.
I don't know.
Well,
I'll allow the
more
question.
than one attorney asked you, more than one attorney here asked you about it. You recall that?
I do.
All right. And in that case, I was assigned. And
Your Honor, I'm going to object if she's inserting herself as a
I'm-
witness.
I'm
It's
not.
entirely inappropriate.
I'm not.
All right,
You,
but
I can rephrase it.
I'll excuse the jury. We'll have this conversation because I don't know where this is going. Please do not discuss the case, ladies and gentlemen.
Do you want me to stay?
Yes. All right, why don't you make your,
Just to rephrase it.
what,
and to-
why don't you make your offer of proof where this is going? Better idea as to what we're talking.
It's going to be short and just a few questions. Mr. Nielsen, you were hired to provide an opinion regarding the conduct of multiple Washington State Patrol detectives, correct?
No, excuse me.
What's that? There's a crying child? Yeah, I know, but I think they got her, think the baby's under control here.
He never tried it, John.
The child's been very good throughout these proceedings, so let's give this child the benefit of the doubt. And he or she is quieted down now. I can't tell because we're so bundled up so much, I can't tell anything about the gender of the child, but anyway, looks like mom's got him or her under control. Anyway, go ahead. You're asking about detectives?
I'm sorry. Can you ask again?
You were asked to provide an opinion in the defense of multiple Washington State Patrol detectives and sergeants.
That's correct.
And it was defending a law enforcement agency.
Yes, it was.
There were no injuries involved in that situation.
That's correct.
That's pretty minimal, Your Honor.
What's that got to do with this case?
They've asked multiple times about me retaining him, and it's been left out there about what type of case it is.
Does it
And
matter?
the fact is, it does matter,
Why?
because it gives a misleading picture to the jury of purpose for what he was retained.
No, it only has to do with the fact that it's, I mean, that's what it goes to.
That's correct, Your Honor. Also, I don't believe anyone got into the facts of that case, other than.
No, no one did, just simply the shot was hired. So to the extent that the state suggests that this witness is either incompetent or biased, it tends to suggest that, well, the state thought highly enough of him to hire him at some point.
It also goes to him, again, representing law enforcement.
Well, yeah. I think that was pretty clear. I mean, the Attorney General's office generally would hire an expert for that purpose, yeah. But if you want to say it was a case, if you want to say only that it was a case that involved the Attorney General's office defending law enforcement in a civil suit, I guess that's what it was, right? There was no criminal charges against these
That's fine, Your Honor.
state officials, right?
That's fine.
I would guess I'd let you do that much, but nothing else. I mean, none of the other details.
That's fine.
Okay, let's have the jury back. Okay, welcome back, everybody. Please be seated. Okay, Ms. Nicolova, re-ask your question whenever you're ready.
Mr. Nielsen, you were retained by the AG's office on a civil case in which I was an attorney assigned to. And in that civil case, it was in the defense of law enforcement, correct?
Correct.
And you testified on redirect that you also made advice to other attorneys on settling, but you've never testified against a law enforcement agency, have you?
That's correct.
You previously testified on Monday about proportionality requirement, do you recall that?
Yes.
And even when force is necessary to achieve a legitimate law enforcement end, it's still impermissible to harm the subject if that harm would be disproportionate to that end, correct?
Yeah, if it's intentional, but there are certainly times where the harm is disproportionate to the lawful effort. There are certainly unintended outcomes that happen. Yes.
And as you've used examples about Walmart shoplifter, right?
Yeah, I think so. Yeah.
And even if it was a legitimate law enforcement end to place that person under arrest based on the seriousness of that crime, you would not place them in risk of harm greater than what's justified, right? I think the example you used, you look confused, and maybe I probably phrased that poorly. I think the example that you used was when you had a lot responded to Walmart for a shoplifter.
Okay.
Do you remember using that example?
Yeah, and I mean, that I might have been speaking generically, but sure. Okay.
Yeah. And legitimate end would be to place them under arrest for, right?
Okay.
And say that person turns and runs. It's a shoplifter.
Okay.
You wouldn't turn around and shoot him with a rubber bullet, would you?
I mean, just under the circumstances that you outlined there, no.
Because you consider the proportionality of the risk of harm to that person, right?
Yeah, in part, that type of force under those circumstances would also be inappropriate. So the harm, yes, but also the nature of the force under those circumstances.
And when you're considering the level of force you use, you're constantly assessing, right?
Correct, compared to the subject resistance, there's a relationship there, yes.
But throughout the time in which you're making the assessment, you're ebbing and flowing, you're moving back and forth depending on what's happening, right?
Correct.
And a reasonable officer should consider the most effective alternative, the most effective and safest response possible in the restraint that's used, correct?
I wouldn't say it that way. No, I mean, I don't know if I'm clear what you're
I'll
asking.
rephrase it.
Okay.
Alright. A reasonable officer should use the most effective and safest response that is proportionate to the threat.
Yeah, okay, sure.
I imagine you've got to agree that officers should not engage in overly aggressive behavior to increase the need for force. Right?
Yeah, no, the issue that I have is necessity. And I think we're kind of dancing around necessity with the words that we're using. And so I would talk about like a reasonably effective alternative when I'm making force decisions, right? And so that's kind of...
Right, and the reasonably effective alternative, you think about what's the safest way to do things, the safest steps that are reasonably effective, right? You consider that.
For whom?
Are we talking, I would object, Your Honor, I think it misstates the law because plus it's unclear if she's talking in 2020 hindsight or at the time of the event. The law is a subjective determination. And that's why the question is confusing.
It's subjective, it's reasonable, objective with a subjective component. And I've not asked any questions on 2020 hindsight because 2020 hindsight doesn't matter for this testimony.
I'll overrule the objection. You can answer.
Can you ask it again, please?
The reasonably effective alternative, you think about what's the safest way to do things, the safest steps that are reasonably effective, right? You consider that?
I mean, I wouldn't say it in those terms because if you find that shooting someone is necessary, that's inherently unsafe for them. And so I wouldn't say, is this a safe thing to do for them? Because it clearly is not.
And that would be completely disregarding reasonably effective, wouldn't it?
What do you mean? I don't understand.
Well, if you needed to shoot someone, your hypothetical doesn't align with reasonably effective.
Well, sure, yeah. I mean, if there is a reasonably effective alternative to shooting someone, then you would do that. Yeah, but I wouldn't say, like, here's a force option that I have, for example, lethal force, and I'm not going to do it because it's not safe for the person. That doesn't make sense. That's not a training principle.
You're right, that wouldn't make sense.
Okay.
That's not the question that I
Okay.
asked, so,
Okay.
yeah. But you do consider the risk of harm to the individual, the suspect?
Yeah, that's a consideration. That we talked about that before.
And it's consideration both of the ground factors and it's consideration of the caretaking.
Yes.
And you testified earlier today that because Mr. Ellis was thrashing about, it was reasonable for Defendant Rankin to pin him down to the ground so he can bang his head against the pavement, correct?
So he can bang his head?
Could not bang his head, correct?
I don't think I said it's reasonable to pin him down to the ground. That's not the terms that I used.
Reasonable to use pressure, push him down between him and the ground to keep him from banging his head.
I think what I said was it was reasonable to put pressure on him in order to stop him from thrashing about. Banging his head would be one of the considerations that you would think of.
And banging his head is the example that you gave, and you gave that example on Monday. You don't want to bash out his teeth or break his teeth, anything of that nature. You remember that testimony?
Yeah, I've seen that happen, and so that came to mind.
And that didn't happen in this case.
It didn't happen, as far as I know, no.
And so when you're looking at reasonably effective alternatives, when Defendant Rankin put Mr. Ellis back in the prone position, there's been testimony, there's been over a dozen officers there when he put him back in the prone position. Remember that?
Yes.
And your testimony is that it was reasonable for him to put his weight on him and pressure on him in the prone position rather than use the over a dozen officers that were standing there to help get him up and hold him in place.
To get him to his feet and hold him in place?
Get him to a seated position and hold him in place.
I mean, if he were willing to do that's a possibility. My understanding is that wasn't feasible based on his conduct.
Did anyone state that they even tried that?
I don't think so, but that doesn't preclude, by virtue of that, doesn't make his decision unreasonable.
You have a number of officers is one of the factors you consider, right?
Yeah, yes,
Number of officers present
yes,
to considering whether or not the amount of force is reasonable, right?
yes.
And you have a suspect that is in the prone position, has said, "I can't breathe," and is in a 4-point restraint. And it's your opinion that rather than use the other officers to help get him up, it's reasonable to keep him in the 4-point restraint with the knees on his back and the pressure on him?
Jack Foundation.
I'll sustain the objection. He never said it was reasonable or unreasonable to sit him up. He just said the force used at the time was reasonable. You've added this other factor of sitting him up. That wasn't anything that was tested.
Wouldn't that be a reasonable alternative to sit him up and be safest alternative for Mr. Ellis?
It's because it's a reasonably effective alternative, okay? And so, if he's hobbled, is the question, should then we take him out of hobbles and sit him up on his butt? Is that the question? Because it's not feasible if he's hobbled to sit him up.
You can certainly undo the hobbles from the handcuffs and leave the ankle strapped.
If that occurred to them, if that was apparent to them at the time, perhaps. I don't know if it was. That's something that maybe they could illuminate.
That would be a reasonably effective alternative, wouldn't it?
If it appeared to exist to them at the time, perhaps.
Or appeared to exist at a reasonable officer at the scene.
If it appeared to exist
To a reasonable officer at the scene.
under the same or similar circumstances, perhaps.
It'd be a reasonably effective alternative.
If it occurred to them, it could have been, but that doesn't preclude what they did, and it doesn't make what they did unreasonable. If there's a universe of possibilities or a universe of options and they pick one, the question is that one reasonable, right?
Reasonably effective alternatives, not just the one that they use. If there's reasonably effective alternatives that are available to them that are safer and reduce the risk to the suspect.
I suppose in hindsight, we could say that, yeah, that might have been one in hindsight. I don't know at the time that occurred to them. I'm not inclined to Monday morning quarterback it.
And so it's your testimony that that one occurred to a reasonable officer at the scene as an option?
That's not his testimony, counsel. It's unreasonable. Ask a different question.
You testified on Monday that you're trained in the prone position at the academy, right?
Yes.
Do it over and over again.
Yes.
And you're here to tell about it, right?
I'm here to-
Counsel,
Joey, that was his testimony.
You're
He
here
said
to
you're
tell
here
about it?
To tell about it. He said.
he's
and
testifying. Of course he's here to tell about it.
Right, that was his words. I'm here to
I would
tell
like
about
you to move on to something that's pertinent to the case instead of churning the same ground.
it. The police recruits that are in the prone position during the training, they haven't been struck in the head numerous times, have they?
Not typically, no.
And it didn't say, I can't breathe repeatedly, did they?
Not typically. No, I assume not. No.
And none of them lost consciousness prior to being put in the prone position, did they?
I don't. That didn't happen here. I don't think. Is that what you're asking me?
I'm asking you, the recruits that go in the prone position in the academy.
No, going unconscious in the prone position doesn't happen very often.
And they weren't unconscious right before being put in the prone position, were they?
You know, I'm gonna just object, I don't know that that's an evidence unconscious before they were.
I don't know that that's a fact in this case. I don't know.
Your Honor, there's been,
Hold on a second. We're now past our normal breaking time, so we'll take our recess and let the jurors have have their break, and we'll continue our conversation about this. Ladies and gentlemen, please do not discuss the case among yourselves with anyone else.
that is asking him about the police recruits, and he said, look, we do it over and over again in the prone position, nobody is hurt, nobody struggles to breathe, there's no issue with being in the prone position. And he talked about it in sports, and he said, I was in the prone position over and over again in wrestling, and look at me, I'm here to tell you about it, is what he specifically said to the jury. I'm here to tell you about it.
So
Prone
what
position is
are
not
you,
wrestling.
what's your
And
point?
the differentiation is, Your Honor, you allowed him to go through that line of questioning
Right.
with defense, and it's not analogous to this case. It's not analogous. We have a case, and I understand that they
So are
dispute
you
that he
claiming that anyone situated as Mr. Ellis was on that night would have died of positional asphyxia? Never mind whether he'd take the methamphetamine out of it, take the heart condition out of it.
No, Your Honor, we can't predict that. I'm not here to predict that. That's not my place. I'm asking a line of questioning to discredit the analogy that defense has used for why prone position is safe. People live through it every day. He lived through it hundreds of times when he did it as a recruit. Recruits go through it every day and nobody has an issue with it. The court
Well,
allowed us to
again,
talk-
I sometimes wonder about where you guys are coming from on the state side of this deal, in the sense that before you wanted to talk about Mr. Ellis's behavior when he was not on methamphetamine, as somehow relevant to the issues of when he was on methamphetamine. Here you want to talk about somebody who, in a situation where everybody has conceded that it's preferable not to be on a prone position if you can avoid it, that we want to put people in a recovery position if we can, that there's training about positional asphyxia for these very reasons. And then your own report says that it's a rare event, however, and he says the same thing, and you try to tear that down. Are you trying to claim this is not a rare event? That's what I'm trying to get at. Because that's all he's saying.
Your Honor, they're not conceding at all that the prone position is a dangerous position.
Well, then I think it's hard to understand Officer Rankine's own testimony about I rolled him over one way and then back another because I was concerned about, he didn't say, I'm not sure if he said it's because I was concerned about his safety, although he does at one point sort of suggest that. But why would he bother to roll him into the recovery position? Why would that be necessary if he was fine just leaving him in the prone position in the first place? I don't see how they get around that.
Well, they put on testimony over and over again through this witness how the prone position is completely safe. There's no issue.
No, that's not what they've said. They haven't said it's completely safe. They've said it is, as you indicated before when you had this conversation during this afternoon's testimony. If there's, of course, he wasn't trying to quantify it, but if there's a 0.5% risk of harm of something happening, obviously that's more dangerous than a 0%. And if you do something else, that may make it more dangerous, but the increase may only be to 1%. So it still isn't more probably than not a dangerous position. And so to some extent, this is about semantics. And I just don't know, what's the point? If you're trying to claim this is not a rare event, that's fine. But I'm not hearing this from anybody, even your own witnesses, and did not suggest that this was ipso facto a positional asphyxia. They said that certainly could happen under these conditions, and that's what we think did happen. Right? What am I missing here? Are you trying to say this is not a rare event? They're not saying it's perfectly safe. They never said it was perfectly safe. This witness didn't say that. He talked about how there was training about positional asphyxia. Why would they have that if it didn't? If it wasn't a risk?
The court overruled my objection yesterday on analogies with sports and the prone position and how people get up from it every day, whether it's MMA or football.
What was your I don't remember your question.
It wasn't mine, it was defense, and I objected to it, and you said it's relevant. And the purpose of
It was his testimony about that, I believe. He was asked a question where it was asked to consider it, but it was in the context of trying to explain or illustrate the point that putting somebody in a prone position is a fairly routine thing when you take a person to the ground and you're trying to arrest them. And death from positional asphyxia as a result of doing that almost rarely ever happens. Does it never happen? They're not saying that. If they are, they're wrong. And that's the reason why they talked about it as a part of a police training. But to try to make it sound like it's more probable than not that somebody put in a prone position in a 4-point restraint will die, I don't think there's any evidence to support that from anybody, including anybody on the state side. It's a risk, and risks are a function of danger and probability. So, I don't know. I mean, we've talked about this ad nauseum, and you just go on and on and on, and making, I think, points that are fairly pedantic at this point. Now, I'm not stopping you, but I'll sustain the last objection. All right, we're at break. Anyway. Yeah, we could get that battle again tomorrow. Okay, welcome back, everybody. Please be seated. Resume when you're ready, Ms. Nicolavo.
Thank you, Mr. Nelson, you agree that in assessing the level of force to use, the officers are to assess whether or not the suspect is an immediate threat to officers or the public, correct?
Yes, that's one of the criteria, yes.
And when Defendant Rankin had Mr. Ellis on his stomach, it's clear that he was in cuffs.
Yes.
It's clear that he had the ankle hobble strap around his ankles.
At the end, yeah, eventually, yes.
And it was clear that the hobble was attached to his cuffs.
I assume so.
And it was clear that Mr. Ellis was not armed. He'd already done the sweep.
Correct.
And he couldn't get up. He was in a hobble.
Correct.
Cinched to his cuffs.
Correct.
Right? And there's at least 12 armed officers there at the scene.
Correct.
And he was not a threat to the public. Mr. Rankin had him on his stomach and had pressure on his back.
Yeah, at that time, I think that when he was restrained, he was not a threat to the public.
Not a threat to the officers.
I mean, if so, minimally.
Nothing further, Your Honor.
Defendant Collins?
Just a couple questions.
Mr. Osser?
Good afternoon, Mr. Nelson.
Hello.
Ms. Nicolavo just asked you, one of the things that officers would have to take into account about the use of force is that Mr. Ellis said he can't breathe. You remember her just asking about that?
Yes.
No. Of course, officers must take that into account, right?
Yes, they should pay attention to that. Sure.
They can't do anything about it until Mr. Ellis is actually under control, right?
That's correct.
And they can't do anything about it until he's actually restrained, right?
Correct. The priorities are make the scene safe, render aid, investigate crime.
Right. Then she asked you about whether officers are trained upon thrashing around being indicative of or could be consistent with somebody trying to get in a position to breathe better. Do you remember that line of questioning?
Yes.
Again, certainly something officers should consider, right?
Yes.
But only after an individual in this circumstance is controlled, correct?
Correct.
And restrained appropriately, correct?
Correct. They have to be under control, and if restraint's appropriate, then yes.
For the same reasons that we just discussed, right?
Correct.
Okay, that's all I have.
Ms. Bremner?
Thank you, Your Honor. No questions.
No questions, Your Honor.
Anything further? Ms. Nicolavo, anything further?
Nothing from the state, Your Honor.
Okay, Mr. Nielsen, you're excused.
No rant.
Thank you. Okay, the next witness for the defense, and which defendant is calling the witness?
Your Honor, Officer Rankin's going to call Asa Lewis.
Your Honor, there is a pending motion eliminating Mr. Lewis that we need to take up outside.
Okay, thank you, Mr. Lewis. Ladies and gentlemen, please excuse us while we have this discussion. Please do not discuss the case. Okay. If memory serves, Mr. Lewis is a forensic toxicologist, is that right?
That's correct. He's a forensic scientist with the state tox lab.
Right, with the Washington State Patrol? Okay. All right, so I'm not sure what he's going to be called to testify about, although I think it had something to do with the effects of methamphetamine and that sort of thing. So why don't you tell us roughly what you think this testimony is going to be, and then I'll have some better understanding when Mr. Liu complains about it.
So he's a forensic scientist and toxicologist at Washington State Patrol Toxicology Laboratory. They perform about 16,000 cases a year. 65% are for DUIs, 35% are for coroner and medical examiner cases. So Mr. Lewis has also worked for, I believe it was in BC, Vancouver, BC, for the coroner's office there. He has published in the area of toxicology. He's done presentations national, or I think within Washington State on toxicology, multiple. He's done hundreds, if not thousands, of tests, both in coroner cases and DUI cases involving methamphetamine levels. He's familiar, obviously, not only through his training and experience, but also through his training experience and educational background in established thresholds for therapeutic levels of methamphetamine, what's generally considered toxic levels of methamphetamine, the concept of toleration, which he's discussed in our interview with him, and he can opine based on the level. He can explain to the jury what tolerance means, what it is, why it's important, what are generally accepted levels in terms of therapeutic, toxic, and toxicity, and so he can also opine in this case based on if there was no tolerance built up in an individual, and given the number of tests that he does, combined with the literature on this issue, that an individual with the levels of Mr. Ellis's without tolerance would be lethal in nature, in his opinion.
Well, my understanding is the testimony has been is in part that even with tolerance we get lethal.
That's right.
Could
The assumption here is that he no longer has tolerance for the drug because he had some period of abstinence.
Correct. So it's a factor within the dynamics at play, which make it, I think, that much more likely that it's lethal. But I think the lethality within the generally accepted principles, and Dr. Clark testified to this, that it's 1,000 nanograms is considered a threshold lethal amount. And actually, Asa Lewis stated that in his interview with the AGs as well. He'll say as well, in response to the question, I'm sure from the state, is, I don't know about Mr. Ellis's tolerance levels. I don't know when the last time he used, other than the fact that we have use here, which is not use built off of a long period of time. But, if he hadn't used in a while, and this is the level he sees, he would consider it lethal. But he's saying, I don't know if he's built up tolerance over a period of time, so that, doesn't make it inadmissible. It goes to weight, not admissibility. They don't have a basis of knowledge or fact to say, oh, he has been using since December, because we don't have any information to say.
Well, there was some offer of proof at one point from a witness who was going to say that at some point shortly before all this, that he told, I can't remember, it was like his landlady, something like that he had
Relapsed 3 days.
relapsed to the use of it. He told her that where exactly what he told her this is not clear, but it was within a few days of this event, I think. And that person has not been called. I think I said you could call her for that if you wanted. With all this other stuff, you couldn't.
No, I don't think so, Your Honor.
I think they also said that you could use it as a rebuttal if this comes up. So I suppose you could still do that.
I believe Your Honor indicated it was hearsay and not allowed to provide that.
Well, that's right, there was a hearsay argument.
There was a hearsay argument because it wasn't a statement against interest, and it's certainly not a statement made for the purpose of medical diagnosis. I mean, Kimberly Mays,
That's right, that's what it was.
there has to be some indication of credibility with regard to the statement as well, in order for it to be really a statement against interest. Some
No,
veracity to it.
It probably wasn't a declaration against penal interest.
Yeah. So, that question was posed to Mr. Lewis as well by Mr. Liu, and said, well, what if he had used, relapsed 3 days prior to this, and then not used for 3 days, and then he has this level? And he said that would not make a difference, in my opinion, as to lethality.
I don't know if you're going there or not, but it seems to me when I was looking at those materials months ago and we were first considering the testimony, and I reserved about this issue. But one of the things was potentially that, I don't know if this was from Mr. Lewis, there was a Dr. Cooper as well, who, I'm not sure if you're still calling her, but I thought I saw somewhere in all those materials something about a person who is got a drug habit and then gets clean and then goes back to using can often make an error in the sense that they anticipate they've got a certain amount of tolerance, that they're used to using a certain quantity of drug, but the fact that their tolerance is gone, now they overdose sort of accidentally because they're not familiar with their own tolerance level anymore because it's been reset. Is he going into anything like that? Because I'd like to know that before I have to send the jury out again before we have an argument about it. Didn't that come up?
I think it goes to
Well, first of all, am I right? Didn't that come up somewhere along the line? Mr. Urbans is nodding yes. So obviously, that's a source I can trust.
It has come up, and I think it speaks to the issue of tolerance again, right? Which is if they're using or not using.
Right, was he going to offer something like, well, Mr. Ellis could have overdosed here because he didn't realize that his tolerance level had changed? Is he going to say anything like this?
I don't think no.
If you're not going to go there, then none of this has to matter, but I just want to make sure, before we get the jury out here and I got to send them again, I want to know if you're going there.
Well, it does matter, Ron, because this whole line of questioning is speculative. Mr. Lewis admitted that he knows nothing about Mr. Ellis. He doesn't know what Mr. Ellis' medical history is, his drug use history, his metabolic rates, frequency of his use. He knows nothing about Mr. Ellis whatsoever. All he did in this case was send out the blood sample to an outside lab, receive the results back, and then provide it to medical examiners. That's all he did in this case.
Right.
It was never endorsed by the defense as an expert witness. We have no opinion.
What do you mean by the state? Never endorsed by the state as an expert witness?
Or the defense.
Oh, then why were we having this motion earlier if they didn't endorse him as an expert?
They never, yeah, well, I think we
Because you guys made a motion a motion limited to preclude him testifying. I'm assuming, why did you do that if they didn't identify him as a witness? We had that I think that came up on the first day of trial. Anyway.
They never endorse him as an expert witness. We don't have a report from him regarding his opinions regarding tolerance or how the methamphetamine in Mr. Ellis would affect him.
You guys,
No report.
you took his deposition though, right?
No, it was this interview that was the defense interview.
Oh.
We were present. So it was, yeah.
Well,
That's all
you were able to ask questions.
correct. But he's a fact witness. All he did was send out the blood sample,
Yeah.
got the results back, provided it up to Clark. That's all he did.
Does it matter if you didn't identify him as an expert witness?
It absolutely does.
We identified him as a forensic toxicologist in our witness. I mean, the state. This is what I find completely interesting about this scenario, right? We have the Washington State Toxicology Laboratory, which the samples here were sent to in a case that's being prosecuted by the Attorney General's office. So Now the Attorney General's office is objecting to their forensic toxicologist testifying about what the lethal levels are of methamphetamine. I mean, to me, that screams at the very crux of this case, which is the prosecutors don't like the fact that this is a huge amount of meth, so they're objecting to their own. I mean, Bob Ferguson in the Attorney General's office represent Washington State Patrol.
Let him finish his statement.
Represent Washington State Patrol. When we tried to set up this interview, we had to do it through an assistant attorney general who was representing Washington State Patrol with regard to subpoenas that we had sent there. And now we hear testimony from these forensic toxicologists who testify about this all over the state for prosecutors. And now the defense wants to present this evidence, and the prosecution goes, no, we don't want to hear about it from our own witness and our own agency that we represent and that we usually call to testify about this stuff. I mean...
Well, in my experience, they don't testify about this stuff, if you will.
Well,
In my experience, what they do is, if this were a case where, in a case like this, for instance, the county forensic medical examiner wants a toxicology report, fairly common in a certainly not rare in an autopsy, sends it to the Washington State Crime Lab to be analyzed. They either analyze it, or in this case, they had some other agency do it. And the report comes back, and later on they may testify, but usually it's about the sort of chain of custody, or if they perform the test themselves, to say, this is what I did, and here's the test, these are the test results, and we got this level of whatever the substance is, in this case methamphetamine and amphetamine, was in the system of Mr. Ellis. And then the medical examiner is the one who concludes what the meaning of all that is. I mean, that's my experience with people in the state toxicology lab. That doesn't mean he's not qualified to talk about this, because he may well be. But I'm not sure it's completely fair to the state to say, well, they do this all the time, and then there's not a peep out of them about it. Not only is there not a peep out of them, they're the ones that advocate for it. Now they're advocating the other side. I don't think that's a completely fair argument here.
We have no problem with Mr. Lewis testifying about what he did in this case, which was sending out the blood sample to an outside lab and receiving the results. But to have him speculate about how that amount of meth affected Mr. Ellis and possibly was fatal to Mr. Ellis and what the tolerance level of Mr. Ellis is completely beyond the scope of what he should be able to, and it's speculative. And he submitted in his testimony or in his interview that without knowing Mr. Ellis' history, he can't opine regarding how that meth would have affected him. He admitted that, and that's what the case law says.
Sure.
That experts should not offer an opinion regarding how a drug would affect someone with just the number, without knowing how that person's history. And that's what we have in this case.
And he does acknowledge, for instance, that tolerance makes a difference, right? Just as a general matter. And so any particular person or individual's tolerance would be unknown to him. In this case, Mr. Ellis's tolerance. I mean, that would be an issue. But are you calling him to offer an opinion about Mr. Ellis's, the effect of this on Mr. Ellis in particular, or just general science here?
Just general science. So when I was looking at the evidence rules as well, I mean, hypothetical questions let's start actually with the qualifications of this individual as well, because he tests blood levels in corner cases and sees blood levels in corner cases and DUI cases for methamphetamine all the time.
Oh yeah, I'm realizing that.
So he knows what's generally considered legal, what he sees in cases, in corner cases, like what the range is in those types of cases, what he sees in DUI cases, what the range in those types of cases are. And when he sees those DUI cases, he also typically can see like how tolerance plays a part as well. If the individual says that they're an active user, if they haven't been using, I mean, those are certain facts that he knows in some of those cases as well. And it's also within the literature on this issue.
Well, maybe within the literature, but I don't know, and maybe he can testify something differently, but it would not be my experience that forensic scientists at the Washington State Patrol who does these kinds of tests would know what the underlying circumstances are very much. They ordinarily don't get a police report, for instance, about a DUI arrest, whatever. And even in a case like this where there's been a death, they ordinarily don't get some kind of preliminary opinion, if you will, from the medical examiner's office. They're asked to test this stuff and tell us what the result is, and not much more than that. Maybe I'm wrong, and maybe he's different, I don't know.
No, Your Honor's correct. That's all he did in this case. His role is very limited. In fact, when he was
Well, in this case, that may be, but maybe in other cases, he can do something more.
That doesn't preclude his prior. So what he did in this case doesn't wipe clean all of his education and training.
No, I grant you that.
19.
Now, Mr. Arbenz has been standing there for a long time, so I'll at least let him say something.
But I mean, tried enough DUI and beyond the assault cases to tell you that it is very common for the state to ask the toxicologist generally about the effects of alcohol or drugs on a person. And the questioning the defense tends to elicit is no different here. We're not talking specifically about Mr. Ellis, but we're talking about the effects of different ranges of both methamphetamine, but also the amphetamine.
The general science.
The general science, exactly.
And then what we typically do as defense attorneys is we come in and we say, but you don't know how it affected this individual. Now, in this bizarre scenario, we have the prosecution wanting to do that, defense doing that, but that's exactly what I'm talking about as to what happens typically.
All right, well, what we'll do is, obviously, there's no general argument that Mr. Lewis shouldn't testify at all. What I'm hearing is that he shouldn't be allowed to offer certain opinions. And I guess if the proper foundation is laid, I may permit it, and if it's not, I won't. And so I guess I'll simply have to hear what Mr. Lewis has to tell us. So, let's have the jury. And this is being called by Rankine? Okay. Okay, welcome back, everybody. Please be seated. And your next witness, I guess, Mr. Conrad, you're calling on behalf of Defendant Rankine, right?
Yes, Your Honor.
And you said Mr. Lewis was your
Correct.
witness?
We call it Asa Lewis to stand.
Okay. Yes, sir. Please come forward. Thank you, Mr. Lewis. Please come forward to right about here, and then please raise your right hand to be sworn. Do you solemnly swear or affirm that your testimony in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much, sir. Have a seat right here. Please state your name and please spell your name.
Good afternoon. My name's Asa Lewis, Asalouis.
Thank you. Mr. Conrad.
One second, I just want to make sure I'm clear on this.
Okay, we'll wait a moment.
Good afternoon, Mr. Lewis.
Hello.
Mr. Lewis, I want to talk to you first about what your occupation and background is. So can you tell the jury what your current occupation is?
Sure. Currently, I'm employed with the Washington State Patrol's Toxicology Lab, located in Seattle.
And how long have you been doing that?
With Washington State, I started in 2003. I did take a year off, had the opportunity to work at a research hospital, but ultimately came back to Washington after a year. Prior to that, I was with the British Columbia Coroner's Forensic Toxicology Laboratory in British Columbia.
So I want to talk also about kind of your education. Do you have a degree?
I do.
And what's that in?
I have a Bachelor's of Science in Biochemistry from the University of British Columbia, as well as a post-baccalaureate diploma with a specialization in environmental toxicology from Simon Fraser University. And that's a school located in Burnaby, British Columbia.
And you said that you used to work at the coroner's office in British Columbia, is that right?
Correct.
And can you tell the jury what your role there was and your responsibilities?
Sure. My main duties were to accept samples that were submitted by the coroner's office in British Columbia and to process the samples to help determine if the person was supposed to be on a medication, as an example, were they taking that medication as prescribed, or were they taking drugs that were off-label use, and did that somehow contribute to that person's demise?
Okay. And about how many cases have you worked on? Well, let me ask you, while you're in British Columbia at the coroner's office, how many cases do you think that you conducted testing on?
Probably in the thousands.
Thousands?
Yep.
Okay. And did you work on any cases or do any testing involving methamphetamine in those cases?
I believe so, yes.
And those were cases involving the coroner's office?
Correct.
So were they death investigations?
Yes.
Okay. And where did you work after British Columbia?
Then I had the opportunity to come down and work with the Washington State Patrol.
And what was your, tell us about your role at the Washington State Patrol.
Sure. So the toxicology lab is responsible for analyzing samples that are submitted by the various policing agencies, as well as the coroner's and medical examiner's offices throughout the state of Washington. And with the cases, very much like in British Columbia with the coroner's and medical examiner's cases, we're asked to determine if a person was taking a certain prescription as prescribed, or were they taking too much or too little. With the police cases, typically there's an observed behavior, and we're asked to determine if there's a chemical in that person's system that could explain that behavior.
So how do you go about doing that, making a determination about whether a person is taking medication as prescribed?
Sure. So very often in police cases, as an example, if there's an observed behavior, we have a form that the submitting agent is supposed to fill out. Contains information such as who the sample belongs to, as well as the submitting agency, basically who we're sending the results back to. They will also fill in sometimes a history of the case. So there may be some sort of observed behavior, or there might be some sort of admission as to what our subject has taken. In any case, regardless of that history, there is a standard battery that the toxicology lab will conduct, and then based on that battery and based on if there's any history, we may do additional testing.
And what do you mean by battery?
So pretty much all cases that come into the toxicology lab, we will do what's known as a volatiles test. And so this test looks for common alcohols. So that could be ethanol, which is drinking alcohol. Could also, it also includes isopropyl alcohol, which is rubbing alcohol, methanol, which is a sort of chemical degreasing agent, as well as acetone. And so we will do that battery or that test, and then if that is based on those results, we may do additional testing. Again, if the history indicates that there is also drug usage, then we will do a cannabinoid screen. So cannabinoids are the chemical name for the active ingredients in marijuana. And also depending on what behaviors are seen, and again, back to admissions, we may do additional testing to look for different categories of drugs.
And can you tell us about what categories you typically test for?
Sure. So we will look for, there's one test, well, we will, one of the first tests that we will do is what's called a screening test. And so this looks for about 200 different drugs, and that sort of helps us direct the testing. So based on the screening test, what's positive in that will reflex to additional testing. So it will capture things such as depressants, so benzodiazepines, any like Valium, Xanax, that type of thing, are all good benzodiazepine class drugs. We will also look for things like stimulant class drugs, so things like cocaine or methamphetamine. Those are considered central nervous system stimulants. We may also look for things like narcotic analgesics, so that would include things like morphine or fentanyl, that type of thing. So we have a broad spectrum of chemicals that we will look for.
And about how many cases does the Washington State Patrol Toxicology Laboratory Division receive each year?
I think last year we hit about 16,000.
And where do you receive samples from?
Throughout the state.
And what percentage of cases come from law enforcement for DUI?
Probably about 70 to 80%.
And what percentage for coroner medical examiner?
Well, 70 to 80, so 20 to 30%.
Okay, so the remaining amount.
Correct.
And so how long have you been working as a forensic toxicologist?
Approximately 24 years.
And are you a member of any professional organizations related to forensic toxicology?
Yes.
Can you tell us about those?
Sure. So some of the organizations that I belong to, one is known as the American Association of Forensic Sciences. There's another one called SOFT, which is the Society of Forensic Toxicology. Also TAP, which is the International Association of Forensic Toxicology. There's a couple other sort of smaller ones as well. In all circumstances, though, they are professional societies, and they do hold typically annual meetings. So at these meetings, the members get to interact with other toxicologists, either locally or internationally, and it's a big exchange of ideas. So very often there will be presentations, and so people from Washington will actually get to see what people from the other Washington are seeing. And so that kind of gives us a heads up of what may be coming our way, or likewise what we're seeing here, places like Louisiana may be seeing it in a few months.
And what about, have you done any presentations or publications on toxicology?
I have.
And can you tell us about those?
Sure. So one of them was actually a sort of a summary study of there. If you remember a few years ago, there was the synthetic cannabinoids. So the lab was doing analysis of this for Washington State and for the state of Alaska. And so I basically took all the cases that we processed and made a summary presentation. It was a poster presentation There was another, or actually it was a poster presentation as well as a published paper. Then there was another one where I did a poster presentation based on the analysis of different foodstuffs and their contribution after ingestion to breath alcohol analysis.
And in your training experience as a forensic toxicologist, are you familiar with what the general effects are of various substances?
Generally speaking, yes.
Okay. And I mean, how have you gained that knowledge?
Sure. So 2 courses that once we're hired on at the toxicology lab that we have to take are offered by Indiana University. And one of them is a week-long course that deals specifically with alcohol and its effects on human performance. And then the second class is also a week-long class, but it deals with various classes of drugs and their effects on human performance. So that's sort of the formal education, and then as part of our continuing education, we are supposed to keep up to date on some of the latest readings from the published journals.
And what about your experience as a forensic toxicologist, like testing various cases? How does that inform your opinion?
So again, if the cases do have a history associated with it that's submitted, our job when we receive the cases after it's being accessioned and put into the system by our property and evidence custodians, we actually have to read the case to determine what kind of testing may need to be performed on that case. So after all the data has been collected and all the testing has been done, we'll go back and reread the case and make sure that it is consistent with what has been observed in the field.
And based on your training experience, are you familiar with established thresholds for therapeutic ranges of various drugs?
Generally speaking, yes.
And what about toxic ranges for certain drugs as well?
We do have references for that, so I typically do not try to memorize those because every drug has different ranges, so we do have references that we rely upon.
And what do you mean references?
So there are various textbooks as well as published papers that researchers have either conducted the research on or have collected data from other established researchers. So we do have various books that we can use as reference.
And I mean, you've been working since 2006 till now with Washington State Patrol as a forensic toxicologist, testing various studies, testing various blood samples as well, right?
Correct. So 2003 I started, and then I took that year off. So right.
And so how does that experience as well inform your opinion as to certain thresholds of therapeutic or toxic ranges?
So with chemicals that are used therapeutically, there are established ranges. However, based on just because you have a value that is within a supposed therapeutic range, there is also the context of how this individual has taken it. So just because you have a range does not tell us, has this person been taking it for a long time or are they brand new to it? So that also will influence the interpretation of the value.
And have you testified as to certain values or effects of substances in court?
Yes.
And how many times do you think you've testified?
Most of our testing is usually alcohol related, but I've been to court probably, well, over 500 times at least.
And what about drug related?
I would say probably about 20% of those.
Okay, 20% of the cases that you've testified in?
Correct.
And who do you testify? Who usually calls you to the stand?
Usually we get subpoenaed by prosecution.
Okay. And
Although I should say, having said that though, we will respond to either party. So either prosecution or defense, we will still show up to court.
And are you familiar with the concept of tolerance?
Yes.
And can you explain to the jury what that means in the context of drug use?
Sure. So I'm going to give you the scientific definition first, and then we'll make it in simpler terms. So with tolerance, When a organism is challenged with a certain level of stimulus, there will be a certain level of reaction achieved. Upon challenge with that same level, the level of reaction is going to diminish. So what that means is, if you remember the first time that you rode a roller coaster, it was very scary, you had butterflies in the stomach, but when it was all over, if you rode that same roller coaster, it wasn't quite as fun, it wasn't quite as scary anymore. So in essence, you had built tolerance to that roller coaster. So to get that same level of excitement back, you had to ride bigger, faster, scarier roller coasters. So this can also happen with chemicals as well as with exercise, that type of thing.
And what about if you don't ride a roller coaster for a long time?
So tolerance, particularly in terms of chemical challenge, is if you do not have a continuous challenge, it is very likely that you will lose that tolerance.
And in your career, how many cases have you, well, let me ask you this. Have you conducted toxicology testing on death investigations involving unnatural, sudden, unexplained, or unattended deaths?
Yes.
Okay. And have you conducted toxicology testing in that area with regard to methamphetamine levels as well?
So if the case involves that, then yes.
Okay. And are there established threshold ranges for therapeutic or medicinal levels for methamphetamine?
There are.
And what are those?
So typically, you would expect methamphetamine levels, if used therapeutically, to range somewhere around 0.02 up to 0.05 milligrams per liter blood.
Okay, 0.0. And what would that be in nanograms?
So we're moving the spaces over by 3 decimal places, so approximately 20 to 50 nanograms per liter.
So 20 to 50 nanograms
Hang on a
per
second.
milliliter.
Correct, milliliter.
Per therapeutic
No.
range.
Can I write this down?
Sure. I think there's a pen up there.
Perfect.
Sorry,
No problem.
I've had to do math in front of people.
Well, it's keeping track of units. So,
Sure.
so we report. So again, 0.02 milligrams per liter. That's 20 micrograms per liter. Right, it is 20 nanograms per milliliter.
Okay, so 20 to 50 nanograms per milliliter would be the therapeutic or medicinal level for methamphetamine.
Correct.
And how often is methamphetamine actually therapeutically or medicinally prescribed like this? Do you see that often?
So the usage for methamphetamine are fairly limited. It can be used if an individual is suffering from narcolepsy. It can also be used as a fairly aggressive ADD, ADHD type medication. And in the military world, if you have an individual that is flying their plane from here to the other side of the world, under the watchful eye of the flight surgeon, the individual may be dosed once or twice with a chemical such as this to keep them awake for that extremely long flight.
And what are the general effects that are seen at therapeutic or medicinal level?
Sure. So again, at lower levels, you would expect to see, because it is a central nervous system stimulant, you would expect to see the person being slightly more active, more talkative. Their temperature may actually be increased. The metabolic rates are increased. And again, they will be kept awake.
And are you familiar with the threshold for what's considered a toxic or lethal range of methamphetamine?
So we have to be careful of that because, again, going back to tolerance, just because there is a published range, if you will, for either therapeutic or super therapeutic, toxic, lethal, depending on that individual, if that person has never used this chemical before, that value may actually be fall under what would be considered sublethal, even though it has extreme effects on that individual. So I believe the published is somewhere around the threshold is going to be around 1 milligram per liter or 1,000 nanograms per milliliter. But I've also seen cases, medical examiners' cases, where that individual has had significantly lower concentrations as well.
So 1,000 nanograms per milliliter, taking into context tolerance, is generally accepted as a lethal or toxic level of methamphetamine.
I believe so.
Okay.
But again, we still have to have that context of the case.
Sure. And you've also seen cases within your training experience where the toxic or lethal level is actually less than that.
Correct.
This case on yourselves or anyone else, please do not view any report on the media, social or otherwise, on the subject of this trial. Have a good evening, and we'll see you tomorrow morning at the usual time.